giving you the admonishments about the dangers of such representation, and you are here today. This is a mandatory appearance docket. Have you received discovery in the case?
They gave me some discovery. They didn't give me the things I requested.
What did you request that they didn't give you?
I don't think they gave me anything I requested.
What did you request? Were you shown the offense report?
If you remember, Your Honor, we went through everything on the record. Everything I had was provided, and I went in detail on the
We
record.
actually had a discovery hearing, and it's all on the record what was provided to you. What is it that you think you are entitled to that was not provided to you?
I didn't get any Brady material.
Brady material is evidence that is exculpatory. Do you possess such evidence?
No, Your Honor, everything that's in my possession, Mr. Davis has.
All right, she doesn't have any. Next.
I mean, all that she gave me was a bunch of opinions. I didn't get any facts.
Did you see the offense report?
I don't see anything in there that was a fact. It was just opinions.
Which is why you have a right to have a jury trial, to have evidence offered and live testimony. What next? You know who the witnesses are, correct? You know who they're saying they're going to call as witnesses.
Again, this is all stuff that I believe we're supposed to provide these facts before they even file this.
You're wrong. Next.
Okay. What about my motion?
Urge it. Urge your motion. You filed a motion. You're
Okay.
representing yourself. Urge it.
Do they have a response to it?
Urge it first, then they can respond.
What do you mean by urge? You want me to read it to you?
No, it's a legal term, which means you said you wanted something. Now you have the opportunity to request that of me.
Okay, I would like you to dismiss this for the reasons I listed in my motion to dismiss.
State's response?
We're not going to ask you to dismiss this at that time. We have enough probable cause to go forward, hence we're here. We need to either set it for a jury trial or, I think we just need to set it for a jury trial, Your Honor.
Do you wish to offer any evidence in support of your motion, sir?
What I've listed in it, yes.
That's not evidence, that is typed words, as you say. Do you wish to offer the court evidence to support your motion?
It is all just typed words, and but these are all court cases that, I thought y'all follow
Do you
these.
want me to rely on your motion to make a ruling? Is that what you're asking?
Have you read it?
Yes, I have.
Yeah.
All right, motion denied.
On what grounds?
That is wrong. That your belief that this case should be dismissed is incorrect. I am denying your motion, and judges do not have to explain themselves to lawyers or to defendants representing themselves.
So your decision is arbitrary?
Your motion is denied. What next?
Have they filed a valid cause of action?
You had a formal arraignment in which you were read your information.
So this
You were
court,
formally charged in this court. The state stood up, read the information, and you entered a plea of not guilty.
no.
I entered it for you because you wouldn't do anything. I have that right. If you do not wish to enter a plea, I enter a plea on your behalf of not guilty.
Twice I've tried to plead guilty, and this is the first time I've heard that somebody's entered a plea on my behalf.
Okay, you're telling me you want to plead guilty to these charges.
As long as I'm informed of the cause and the nature.
See, you don't really want to plead guilty. You're challenging this court's authority to even hear your case. So when you challenge the jurisdiction and authority, I can't let you plead guilty because you don't really want to plead guilty.
I do. I'd like it to be explained to me what the facts are. And all I've gotten is opinions.
Sir, this is how it works. You read an offense report, you look at your discovery, and people make decisions as to whether they want to enter a plea of guilty to a judge or whether or not they want a jury trial. There's not much in between here. You either want a jury trial or you want a bench trial, or you want to a disposition. Those are the options.
What facts have they provided?
Sir, we're not here about facts. That would be
Well-
a jury trial.
Aren't facts being presented part of due process?
Sir, I'm not going to argue with you.
I'm not trying to
This is a
argue.
hearing in which two things occur. I ask if you've reached discovery, which I already had a discovery hearing, and I'm asking you now if you are rejecting the state's offer of disposition.
That they offered me the first time I came here for probation?
Yes.
I don't see why I should take that.
Okay, so you're rejecting the offer. So the next step, and the only thing that happens today, is I set your case for trial.
Even though every time I've come in here, I'm trying to plead guilty.
You're not really
Ha-
trying to plead guilty. This is what, every time I say you want to plead guilty, you say, well, nobody's shown me any facts. Nobody's established jurisdiction. That's kind of how I feel, but you can't do it.
Am I presumed innocent?
Yes, sir.
How can you presume me innocent while assuming that these codes apply to me?
Well, what?
The first time I was in here, you said that you already assumed that the code was applicable to me.
Sir, you're in the state of Texas. We have a penal code.
Are there facts to go along with
Your
that?
body was in the state of Texas, in the county of Gregg, if they proved the county of Gregg. And so, yes,
You're already assuming that those are facts?
I'm assuming I have jurisdiction over you. Now, that could be proved wrong if it turns out that your body was not here. But at the moment, yeah, you're in my jurisdiction.
Isn't jurisdiction an element of the crime?
This is not the time we argue about this, sir.
I'm not arguing, I'm
Yes, you
asking.
are. This is a
I want to
mandatory
plead guilty.
appearance.
I want to